Hello, everyone, and welcome back. We were just live talking with Jim McCarthy and Daniel Buttafuoco, and on the show, Ask Your Injury Lawyers, and that was part one. This is going to be part two of Ask Your Injury Lawyers, where we are going to address all of the questions and concerns people have as it relates to COVID-19, the coronavirus pandemic. And it's a perfect topic for our two guests. We've got Jim McCarthy, who is a resident medical malpractice attorney. We've got Daniel Buttafuoco, who is the founder of Buttafuoco and Associates. So we're going to launch right into this, into our hot topic here, medical malpractice and COVID-19, the coronavirus pandemic. Let's first welcome back to the stage. We've got Jim. And we've got Dan. Welcome back, guys.
Well, it's nice to be here. Thank you, Rob. Hi, Jim.
Hey, Rob. Hey, Dan.
So I appreciate you guys doing a part two of our two-part series. Again, if you guys would like to learn a little bit more about Jim and medical malpractice and some of the questions that we addressed in part one, you can go ahead and check out that video. In this part two series, we're going to be talking a little bit more about medical malpractice. But first, I'm going to put these guys on the hot seat, and we're going to be talking about some controversial topics. But we're also going to be talking about some of the questions and concerns that everyone has right now in light of what we're going through, and that's the COVID-19, the coronavirus pandemic. So let's just go right on into it. Oh, again, everyone, yes, we're still going to be feeding questions. Let's put our little ticker at the bottom. And so, yes, everyone is welcome to still submit questions. We want to encourage everyone. If you've got a question about anything, these are our two highly respected attorneys, incredibly intelligent. They know all areas of law really well. But we've got Jim McCarthy, our resident medical malpractice attorney. And again, the founder of Buttafuoco and Associates, Daniel P. Buttafuoco. And again, if you guys have questions, this is your opportunity to ask them. Just all you got to do is right below this live video, you just simply submit a comment on this live video. We'll be able to see it, and the attorneys will be able to answer it. But guys, let's get right into this whole COVID-19 thing. Now, New York has become sort of the epicenter of coronavirus for the pretty much for the entire world. And at the moment that we are streaming this, it seems to be reaching a plateau. So first, as from the legal end of things, let's just answer the question directly, because Jim, we were talking about this off camera a little bit, but let's just answer this correctly. If someone actually contracts coronavirus, let's say they want to blame contracting it from a nurse, is it grounds for a medical malpractice case?
Absolutely not. In the last New York State budget, there was immunity given to doctors and hospitals for any cases related to coronavirus. So it's totally off the table. You're not going to sue a doctor for contracting the virus. There's really nothing actionable, which makes sense because we're in unprecedented times. And, we all have to work together. We can't bring cases like this. And even legally, it doesn't make much sense because we're dealing with something that there is no standard. When you want to prove a medical malpractice case, you have to show that they departed from the standard. But we don't have a standard for this. We've never lived through anything like this. So that combined with the law put forth by New York State indicates there's no cases.
Now, does that mean that there are going to be no medical malpractice cases at all during this time?
No, anything related to the virus is off the table. It just is off the table.
Yeah.
Tangentially, you may have situations, but this is not a great climate for medical malpractice cases either, because the doctors and nurses that are working for us are saving lives, and it's not a time to bring lawsuits against them.
Yeah, I actually think
that's my feeling.
Yeah, no, you're making a great point. I mean, these all these first responders, all the medical staff. I think we're at a place where we should be focusing more on, if anything, thanking them for being, if we can call it, the front lines of this pandemic.
Well, we just did thank them. My daughter recently had a baby, and we sent about $1,000 worth of lunches to the entire OB/GYN staff of Stony Brook Hospital in the name of the firm, thanking them for their heroic efforts in helping my daughter to have a beautiful baby girl at this very difficult time. Not only that, but my other partner, Mark Freely, did a similar luncheon for a group of doctors at Stony Brook that are actually treating the virus. So we're very much in support of our healthcare professionals at this time. Having said that, if you have a valid medical malpractice case, not a case where nobody's hurt or there's no liability or the doctor didn't do anything wrong, but a valid case where the doctor departed from good and accepted standards, we're still willing to review it, but we would probably wait till this thing subsides before we actually file papers. And not only that, but it won't come up for trial for another couple of years. So by then, hopefully this is a distant memory and we can get back to the norm, which is normal medical conditions, normal treatment, normal protocols, and normal standards of care. But Jim is 100% right. As far as the coronavirus itself, it's going to be very difficult, and nor would I recommend trying to hold anybody responsible for getting it. I think the best one we're going to see in terms of that is going to be workers' comp cases. We already got one workers' comp case where somebody was not given proper protective equipment and they contracted the virus. And we're going to see cases like that where people are, where there's no issue of how they got it. As long as they got it at work, then it would be covered by workers' compensation. I think many of the medical professionals are going to be covered themselves by workers' compensation in terms of cases where they contract the COVID-19 virus while they are performing their heroic duties. And I would think it would be hard pressed for any workers' comp board judge to deny them on the grounds that we don't know where it came from. I think when you're exposed to this day in and day out, and you're practicing self-quarantining, and then you're going in the morning to your job and working a full shift and coming home and not seeing anybody, I think it's going to be pretty obvious you contracted that virus on the job, which would give rise to a workers' compensation claim. But as far as malpractice, I don't see it.
Now we're at unprecedented times, right? And so, Jim, you had mentioned that they had worked into the budget where there's immunity for the doctors. That sort of ruling, is that a permanent ruling, or can that be sort of readdressed a little bit later on when everything settles down?
I don't think it's ever going to be readdressed. I think it's fair. I think that it's the right thing for what we're dealing with right now.
Now, let's just, we had some people asking some questions here, and I'll just sort of ask it on behalf of our audience here. And they want to know is, what if someone actually is injured? This is a scenario question. They go to a hospital to get treatment for some type of ailment, but because of the fact that the hospital systems are overwhelmed, the medical staff is not able to treat them in time, and then that injury gets worse, or worst case scenario, they die as a result of not being able to get medical care. Is that a case?
That would be a case. Yeah, if it's not directly related to the virus, it would be a case. So if somebody goes in there and is misdiagnosed or something like that, is having a heart attack and is misdiagnosed and not attended to, that would be a case. They still have to provide competent medical care. Yeah. Even though they're overwhelmed, and that'll be their defense, that we were overwhelmed, but it's not a great defense. I think that they brought in a lot of different medical professionals from other states, so they're fairly well staffed. they're still held to the same standard. I don't
Yeah.
think everything is out the window.
I would take issue with the idea that they're overwhelmed. Actually, according to the most recent reports from the governor, the actual number of patients who we thought were going to flood the hospitals in this tidal wave of sort of patients that we couldn't address never really happened. Thank God. So I think that the hospitals are going to be, thankfully, going to be held to the typical and usual standard of care. Although I can envision, some creative defense lawyer trying to raise what I would call the COVID-19 defense, in front of a jury, ladies and gentlemen of the jury, this patient came in the middle of a pandemic and, we were running around and, it was a different world then. And maybe that would fly in terms of a factual argument. But we'll be able to address that. As Jim rightly points out, the standard of care isn't going to change unless it's palpably provable that, they were physically, it was physically impossible for them to render normal care. So I'm not worried. It's sort of very similar to, I don't know if you remember, about 10 years ago, we had a winter in which it was one ice storm after another. Remember that, Jim?
Yeah.
We got hundreds of slip and fall cases on ice, and everybody was saying the same thing. It's going to be the winter of 2008 defense, whatever that year was. I don't remember. Where they're going to say, that was the year where we were overwhelmed and we couldn't address it. But it doesn't change the fact that you have to provide a safe walkway, and you cannot leave ice on your driveway. And, if you're operating a commercial establishment and you're encouraging patrons, I don't care how bad the weather is and what the situation is, you have to have a walkway that is safe. So it's sort of in the same vein. Wouldn't you say, Jim?
Yeah, and I think after the passing of time, people tend to kind of forget, not forget, but kind of it dulls the episode. You kind of don't remember it as vividly as what we're living through now.
Yeah.
And these things all take time. So I think once the dust settles here, and I think we're headed in that direction, I think it'll be fine.
Just to remind everyone, especially for those that are tuning in right now, we are with Jim McCarthy, a resident medical malpractice attorney for Buttafuoco & Associates, and the founder of Buttafuoco & Associates, Daniel Buttafuoco, where we're talking about medical malpractice and COVID-19, the coronavirus pandemic. Jim, let's sort of revisit this a little bit. Can you just share with everyone, let's re-educate everyone, what constitutes a medical malpractice case?
Well, a medical malpractice case is when a doctor or a hospital or care provider departs from what's good and acceptable. It's fairly a low bar. If the medical care is acceptable, you will not be successful in that case. Acceptable is not great. It doesn't have to be wonderful. It doesn't have to be the best. You could have gotten better care from somebody else. It still doesn't make it a case. So it's a fairly low bar for the doctor. You need a case where the consequences, the injuries are catastrophic in nature, because these cases do not settle easily. You've got to litigate them for years. You have to spend a lot of money and time to bring them, and they're not easy.
Yeah. What would you consider to be what's a catastrophic injury?
A catastrophic injury is something that is just like I said, catastrophic. It's loss of a limb or a cancer that you could have otherwise beaten, but you can't now because you were misdiagnosed. A lot of people come to me with wrongful death cases, and the wrongful death law in New York State is terrible. It's really abysmal. It's you can only get compensated for pain and suffering and lost wages. And that's it. Not the emotional love that you may have had for a family member who has died. So it really affects the elderly and the young. They especially if you die quick, if you go under for surgery and you wind up dead at the end of the surgery, there's no pain and suffering. And if you're not supporting somebody, the case has no value. And I tell people this, and it's difficult.
I would think that also they might be taking it personally, and and I think maybe you both can sort of shed some light on this. That when you are giving advice about a situation, you're not trying to be insensitive to their situation. You're just giving advice based on what the law dictates, right?
Quite the opposite, actually. We're actually trying to be sensitive, and unfortunately, they're not taking it that way. One of the hardest things to tell people when they call up and they say, grandma died, she was 95 years old, and the doctor did something wrong. It's like, yeah, it's sad, but, I hope I live to 95. And, under New York law, and I tell them, we don't make the rules. We just operate under the rules of New York. And by the way, New Jersey has the same rule. It's called the pecuniary loss. You're only allowed to sue for the financial value of the person's life. So as Jim rightly points out, what is the value of a small child or a very aged person under the law? That doesn't make us heartless people. In fact, it's very difficult to tell this to someone. We're actually very compassionate. We care deeply about our clients, but, we have to tell them, look, the law provides that your client, your loved one isn't worth enough to bring a case, because it would cost more to file the case than it would be what we could collect. And it's just not possible economically to do that. And I always tell them, we don't make the rules. If you don't like the law, you should write to your legislature. We are trying, the trial lawyers group that I'm a part of is trying to change this law for many years. This law dates back to 1840, before the Civil War. And it is a very archaic and very bad, very harsh law from a time when life was not valued. You just picture the Civil War. People were just marching into a hail of bullets. They had a different idea of the value of life then than we do now. And so these were times when, when they thought it was advisable to only be able to sue for economic value. Now, we certainly know that lives have more than economic value. By the way, that same principle applies to animals. You can't sue for animals. You might have a pet, a dog that you love dearly, that has been your companion for years, and somebody runs it over, and the value of that dog is the value of to buy a replacement dog. A few $1,000s.
Yeah.
And I know Mark, our other partner, who's very involved in animal rescue, particularly dogs, is very keen on changing that law. But it's the same principle. It's this principle of economic value. In a death case, the cases that have value is a breadwinner, somebody making a lot of money, a construction worker, a professional, a teacher, a cop who gets killed and leaves a family, or a mother with young kids. Even though a mother doesn't make a salary, the mother's life has value. A pecuniary value is the correct term to the children, because the mother is teaching those kids, how to grow up and how to be good human beings and nurture. It's called nurture, care, and guidance. You're allowed to collect for that. But a 95-year-old woman, no one is dependent on her, and that's sad. It's sad, but that's the law. And a 3-year-old kid, no one is dependent on that person. In fact, that person actually, it costs money to raise that kid. That person is actually financially a negative on their parents until they grow up. So we can't take death cases for very young people and very old people.
But for people that are tuning in that are not from New York, is that a universal law?
No, actually, that's a great point, because the case I handled in Iowa that I referred to earlier in another program, I had a medical malpractice case in Iowa involving a 12-year-old boy who died under anesthesia, no pain and suffering. The anesthesiologist administered the wrong anesthetic for someone in that age group, and he succumbed to exactly the type of complications that were meant to be prevented. And it was no pain and suffering. And that case settled for multiple millions of dollars because Iowa has a different law than New York and New Jersey. And Iowa, as in many other states, Nevada is another state that allows you to recover for the emotional value of the person, the fact that that person is gone and you are grieving. But you can't do that in New York, and you cannot do that in New Jersey.
Now, I've got a question. Now, I know you guys are firm on your belief that right now, there's going to be no medical malpractice cases. We're just talking about New York, I guess, with regards to the ruling in the budget that says that medical staff has immunity. Now, do you think, though, for someone listening, do you think that they should take it upon themselves, though, to determine whether or not they have a case? Shouldn't they, regardless, still sort of seek the advice from an attorney?
Well, it's only corona related injuries or deaths. It's not a blanket immunity for everything. So, there are still going to be cases, and it just can't relate to the virus.
Yeah.
And also, to directly answer what you're saying, always I encourage people to call us or email us, because you're not able to decide if you have a case or not. There are people, I'm sure, listening to this who think they have a case and don't have a case. And there are also people listening to this who have a case and don't think they have a case. Let me tell you about one case that particularly sticks out in our mind. Jim and I were sitting in our office on one fine Tuesday afternoon, and a woman walks in from a restaurant that we frequent. We were friends with her brother who owned the restaurant. Wonderful people, Afghani people. And she walked in and said she had misdiagnosed breast cancer. She pulled out a film, a CD. No, she pulled out a report of a MR was a sonogram, and it showed that a mammogram actually, and showed that it was read as negative. And we looked at the time period, and we realized that the statute of limitations was expiring tomorrow. So this was Tuesday. Wednesday, the statute of limitations was expiring. So we did something which I think Jim and I did, which was nothing short of heroic. We called, we immediately sent her to the radiologist to get the films in a CD. And she went there and came back an hour later. In the meantime, we called my neighbor, who is an expert radiologist, and we said to him, Barry, can you look at this? He says, you're not going to believe this. I'm passing your office right now. He pulls into our office. We put the films up on the computer. He says, there, I see the cancer right there. It's a case. We filed suit that afternoon. I don't think anybody could do that. And we settled that case for 7 figures. And it was a serious case, but we were able to nail it in time. So, I guess the thing is, you have to be sort of be able to think on your feet, and you have to be very mobile and versatile, and you have to address these things when they come in. You never know what's walking in the door. Now, that particular case was a lady who was married and had pecuniary value under New York law because she had a husband that she provided services to in terms of, working. She was employed. She was a good wife. She took care of the house, and they had an economic partnership in that marriage. And so those cases, we can take. But had that been a 95-year-old lady, wouldn't be anything we could do with that.
Now, just a scenario.
You remember that?
Oh, yeah.
I'm sorry?
Unfortunately, yes.
Yeah. Here's one thing. You guys actually remember every single case. I'm always shocked. Anytime we guys have conversations, you guys are always like ping-ponging stories back and forth. And you're like, I remember back in 1999, Sally Sue. And I'm like, what?
I not only can remember them, I can actually see them in my head, which is really
thousands of them.
Oh, well, listen, you guys are dealing with these cases intimately for a very long time.
Yeah.
Yeah, that was something.
You know, it makes sense. Now, here's a scenario question for you guys. Let's say, you know, obviously not everyone that we're talking with right now currently is a victim of medical negligence, but maybe some of our viewers know someone who might be the victim of medical negligence. What would you recommend to this person, how they can sort of be an advocate for, whether it be, you know, Jim or Dan or just a medical malpractice attorney in general, to advocate on behalf of like a friend or a family member? How can they
give us a call? Just give us a call.
Yeah, Jim is a man of few words, and I agree with that. Give us a call. But I just want to make clear something, that we do not sue people lightly. I believe personally and very strongly that lawyers are the first line of defense against bringing a bad case. Lawyers have to be able to tell their clients, I'm sorry, you were hurt, but it's not a case. And I know lots of lawyers are very afraid to do that. I see what lawyers do, and they pass the buck to the next lawyer, you know, and they say, well, we can't take your case. And they don't say why, because they're afraid of liability. So that person shops at the 10 lawyers until they come to us. I wish they'd come to us first. And I say to them, and Jim, you've done this. I'm going to tell you something that no lawyer is going to tell you. You don't have a case. And here's why. And they're like, well, I wish somebody would have told me that. I'm like, yeah, because lawyers are chickens. People are afraid of liability. They're afraid to be honest. I'm not afraid to be honest. It's funny. We use a lawyer in New Jersey. I'm not going to mention his name because he has his own firm, but he's a very close friend of mine. And he writes beautiful letters to the clients when he rejects a case. And I commented on it. I said, you know, his first name is Dennis. I'm like, Dennis, that's very admirable that you take the time to explain to the poor client why you're not taking the case, because so many lawyers are afraid to go on the hook and they just pass the buck and they say, well, we can't take the case. That's not an answer. I'm sorry. People deserve an answer. They need to know why the lawyer's not taking the case. And we're not afraid to tell them in plain English. And maybe that's why people accuse us, especially Jim, of being grumpy or of me being overly frank. One thing I am is I'm brutally frank and brutally honest with people, almost too honest, I could say, my wife would say, and I'll be able to tell them, look, do you want to hear the truth or do you want to hear a story? Do you want to hear what you want to hear or do you want to hear facts? And usually if they have a half a brain, they're going to say to me, you know, they'll give it to me straight and I'm going to tell them the way it is. I think that's something that, you know, is, to me, if I had a case, that would be valuable.
Now, guys, just sort of for your counselors, your closing remarks, sort of speaking. But what's one sort of passing comment that you'd like to leave with everyone right now as we close out this discussion about medical malpractice, COVID-19, the coronavirus pandemic, the current state of medical malpractice? What sort of comments would you like to leave with everyone?
Well, if you feel like you or someone in your family was a victim of malpractice, it never hurts to call. Just call. I listen to people all the time. Big case, little case, anything that you may want to discuss. That's what we do. We're here to listen to you and help you. And if you don't have a case, I'll let you know. But if you do, we will certainly help you. So if you think that you've been a victim of malpractice, give us a call. And
what I would add to that is that if you are willing to talk to us, at least be open-minded about what we have to say. We're not in the business of telling people no for no reason. We're not going to reject your case lightly. Well, we have no reason to do that. We only get paid if we win. And we know what it takes to bring these cases. And if you have a case, we're going to bring it and we're going to put our heart and soul into it. But if you don't have a case, please accept our explanation when we tell you it's not a case worth bringing. And we'll give you reasons. We're not just going to, just blow you off. But, so many times I hear from people who, and this sort of drives us crazy, where they think they know more than us. And it's not that we're infallible, but we've been doing this for so long. We must have reviewed, if I say we reviewed 1,000 cases, I don't think I'd be exaggerating.
Right.
We probably, like Jim said, it's probably 30 cases a week.
Yeah.
And that this is really in the form of pro bono legal advice and legal services. We don't charge for this, and we're on the phone sometimes for hours at a time. People say, well, you settle a case for millions of dollars and you get a percentage of that. And look how much money you make. But they don't look at all the times that we take on clients and causes and we don't make a penny. And we spend hours, tens of hours, hundreds of hours sometimes, reviewing stuff only to say, there's no case here. So it's really a very mixed bag. And sometimes we get cases where clients come in all meek and humble and they have the greatest case ever. And then we get these other people that come in with a big attitude and they want to yell and they want to scream at us and they're telling us what a great case they have. And we're explaining to them why it's not a great case. And then they curse us out and hang up. There's no way to treat somebody. Be humble. We're very respectful of our clients, of the leads. We're going to be honest with you. We have no reason to lie to you. We're going to be straight up, and we're going to tell you the way it is. I treat people the way I would want to be treated. That's the rule I live my life by. That's the rule by which we run the office. We treat people the way we would want to be treated, but I do expect that same courtesy in response. You don't have to bow to us, but you can push back. It's fine. But when we're telling you something and when we know what we're talking about, it would behoove you to listen to us because we're not novices to this. We're very highly trained in our office and we're very highly experienced and we don't take this job lightly. I just want to tell people that. I want to give you a measure of confidence in who we are and what we do. We weren't born yesterday. We've set a lot of records. We've been doing this a long time. Other lawyers send us cases. Judges have sent us cases. Doctors send us cases. We're known experts in the field.
You guys both are, and so is everyone from your office. I do appreciate you guys actually spending some time with us today to go into detail of answering some of these questions as it relates to medical malpractice and COVID-19. I know both of you guys are still working very, very hard. This is not a coronavirus vacation for you guys. So the fact that you guys were able to carve out some time to spend some time with us is something that we all really appreciate.
Let me ask a question, Rob. I want to ask Jim a question. Right now, while you're home, how many cases are you working on to see if there's a real case there? Just give me a rough idea. How many?
4.
4 separate piles of medical records.
Piles of records.
All right.
4 piles?
Yeah.
Piles.
4 cases. 4 separate cases, which are going to be 4 piles of medical records.
10,000 pages, 4,000 pages.
Wow. Is that really, the sort of
my desk.
the volume of records for a case?
Yes. Yeah. And you wonder why I love this guy.
Wow, that's not light reading, huh?
I like it.
We're all a little strange in a good way.
Yeah. Well, listen, when you're hiring a medical malpractice attorney, you want someone that absolutely loves it, or else I don't know that you're going to get the same type of result.
That's true.
Absolutely.
Truth is good.
So again, and even to our audience, thanks everyone for tuning in for this special part 2 of our 2-part series with both Jim McCarthy and also Daniel Buttafuoco of Buttafuoco and Associates as part of our show, Ask Your Injury Lawyers. Until next time, we'll be doing this every Tuesday and Thursday for the time being at 3:30 p.m. where you guys can tune in, you guys can ask your questions, and your attorneys will be here to answer them for you guys. Attorneys, counselors, esquires, lawyers, thank you again. I appreciate your time, guys.
Thank you, Rob.
Thank you, Rob and Jim.
All right. Take care, guys.
Take care, guys.